and then we'll just wait for 2-3 minutes for people to come in and go from there. Have you started live streaming?
Why is it not letting me go live now? It's freezing. Why is it freezing? Okay, I might have to refresh really quickly because it's freezing on me.
Yeah, I can do it from here.
Are you sure? It's like not letting me, it's like not letting.
I can do it. That's not me.
I don't think the live stream has started yet because someone that's supposed to be in live stream is texting me.
Right.
Saying she's not seeing it yet.
I'm just doing that right now. All right, I'm pausing my audio. Bye, guys. And the live stream is starting in 3 seconds.
Okay, hi everyone. Welcome to our event. My name is Sejal. I am the Health Policy Director for the North American Association for International Students, otherwise known as NAAIS. As an organization, we bring together Indian American and Indian national students to foster a community and to promote dialogue about a variety of topics. We're so excited to host today Kalpana Anand and Tejas, who are immigration attorneys and members of the South Asian Bar Association. We hope that this event helps provide more information for international students impacted by the recent ICE directive. So without further delay, Tejas is our moderator for the evening, so I'm gonna hand this event over to him.
Thanks so much, Sejal and Sudhansh, for giving us the opportunity. I'd like to begin by just giving you a little bit of background about the South Asian Bar Association in North America. We are an umbrella organization for various regional South Asian bar associations and South Asian legal professionals throughout North America. We do seek to strengthen the rapidly growing legal community. And really what we do is we provide a recognized and trusted forum for professional growth and advancement and for promoting the civil rights and access to justice of the entire South Asian community. Now, we also have a very active immigration committee. Both Kalpana Petty-Botla, who's one of the speakers, and myself are both former co-chairs of that committee, and Anand Sinha, who's our co-panelist, is one of the current immigration co-chairs. We are very committed to supporting and being there for our community. It's been a very tumultuous 3.5 years. We recognize that, and we empathize with everything, with so many of the issues that individuals who have dialed into this webinar are experiencing. We hope that we can provide some insight on issues and also give you a forum to advocate for yourself. Those are really the primary goals that we have today. At the same time, we want to make it very clear that even though we are going to try to provide guidance and advice today, we cannot provide personalized or individualized legal advice to anybody. The advice that we're providing or the information that we're sharing with you today does not create any sort of attorney-client relationship between any of us and anyone who's listening to the webinar. And we're certainly not telling you exactly what you should do individually. So please do bear that in mind as we continue with this webinar. So with that, I'm going to switch it over to Anand Sinha. Before I do that, I just want to make sure you all know that you're geographically covered across the United States with the three of us. Kalpana Petty-Botla, who has her own law firm, is based out of the San Francisco Bay Area in California. Anand Sinha, who also has his own law firm, is based out of New York City. And I do not have my own law firm, but I am based out of Chicago, Illinois. So we've got the Midwest, West Coast, and the East Coast covered here. So with that, Anand, take it away, please.
Sure. Thank you so much, Tejas, and thank you, Sejal, and the entire team to organize this event. So let's get down to business. The reason we're here today is if you're not sure you're in the right place, this has to do with this changes by ICE to basically rescind their previous guidance in the wake of COVID-19. So the way we're going to set this up, I'm just going to go over some general guidelines on what the program looked like previous to ICE, which is the Immigration and Customs Enforcement. It's a part of the Department of Homeland Security, which is tasked as the government agency with the enforcement and execution of the immigration laws in the United States. So before COVID-19 even hit, the general rules of governing student visas is found at 8 CFR 214.2-F. And the main thing you want to know about that is one of the key provision within that regulation that we're going to talk about today is regarding a full course of study. So a full course of study basically means, as it says on the screen, you're only allowed to take either one class or 3 credit hours per term online or remote learning. What's the reason behind this? The policy justifications that ICE always had for implementing these regulations was that they wanted to make sure there's no fraud going on, that that some universities that might set up as remote learning universities, well, are they also kind of selling immigration benefits? And there were some universities that were somewhat on the fringe in terms of, well, were they actually operating under the guidelines? And that's why ICE and enforce these regulations. But for the most part, this was never really an issue at the scale it was today until the COVID-19 pandemic hit. Obviously, with the scope of this unprecedented pandemic, universities had no choice but to offer remote learning opportunities. They weren't allowed to hold in-person classes. Not just universities, the entire country came to a standstill, right? And without any kind of precedent, this has never taken place in the past before, ICE issued basically a notice to stakeholders that they're making exceptions due to the COVID-19 pandemic. So we can go through some of the basic exceptions, but primarily what you really need to know is that there were 3 exceptions made. So one was that if a school closes temporarily without online instruction or other alternative learning procedures, the student should remain active in SEVIS, as long as the students intend to resume their course of study when the class is resumed. So that's like, let's say the school that's scenario 1. So that's if the school completely closed and does not have online courses or other alternate learning procedures. Some of you might have been in that situation, but I'm pretty sure a lot of you might find yourself in scenario 2, where a school temporarily stops in-person classes, but implements online or other alternative learning procedures, and non-immigrant student remains in the United States. So essentially, this is the fact pattern I'm assuming many of you are in. And forgive me if that I'm not including everyone, but this fact pattern really is, in terms of what's taking place in the United States right now, this is what a lot of schools did. They didn't want to cancel their semester. They didn't want students to be out of the ability to finish their classes, earn their degrees, or respectively move on with their career. So due to modern technology and things like we're using right now, Zoom, they're able to teach their classes remotely. And ICE recognized that, because of this extraordinary circumstance posed by COVID-19, you could allow international students to participate in online and remote learning and have their SABA status remain active. So the key provision within the March, this was issued on March 13th, is they said that this is a temporary provision, but it'll be in effect for the duration of the emergency. They didn't obviously give any guidance into when would this emergency end, because it's a fluid situation. And all the universities, all the students made their decisions in terms of how to plan out their future based on this guidance, this March 13th guidance. And it's, I'm sure many of you may have even decided, if we can do remote learning and we're still in status, that we might, secure a lease in the United States for our housing arrangements. The universities put committees together to plan out their, how to go back in terms of resuming classes in the fall. So this is all well thought out by both students and universities based upon this guidance. There's a lot of reliance issues involved. And to go on from there, on June 6th, ICE kind of took a step back and they issued a new directive, basically saying, in layman's terms, that the previous guidance we issued that allowed for remote learning will not be applicable in the fall semester. And they basically are telling students that if you are enrolled in a university that offers 100% or all of their classes online and remote learning, you will not be in status, in lawful non-immigrant status as an F1 student if you're enrolled in one of these universities. This came as a big shock. And Tejas will talk about the litigation later, and one of the words that's in the motion is they threw Harvard, MIT, and other similarly situated institutions into a state of chaos. And this is exactly what we're in today. So among other things, this directive, basically, it's going back to the way things were previous to the exceptions made for COVID-19. So the law hasn't really changed, but the exemption has been rescinded. So we go back to the way things were pre-COVID. And for students and universities that had already planned their in wake of COVID-19 and in wake of protecting the health of their students, their faculty, and their communities, they had made plans to do remote learning and online learning. And now this whole directive by ICE throws a big wrench in the equation. What is allowed now? What solutions are available to students? And what options are available to lawyers and the universities to advocate on behalf of their students? So I don't know if Tejas, you want to add anything to the brief overview I gave right now, but I think everyone's going to want to learn a little bit more about the MIT and the Harvard litigation as well. So.
Yeah, absolutely. I think they're just addressing one question that came up during your portion on it, which I think is likely to be on the minds of many people. The question that was raised was, what happens if there's a change in circumstances during the course of the semester? So supposing a university initially says, okay, we're going to give this hybrid approach a try, or we're going to try to go in person, and then all of a sudden, state orders change, or there's a huge surge in that particular state, and the university now decides that they're going to switch to an all online model instead. What are the consequences there? I don't know if you want to speak to that, Anand, or Kalpana, if you want to speak to that.
Well, I think that's part of the uncertainty, right, that's being created, because arguably in the March 3rd understanding that indeed the response for international students as well as universities should be taken based upon what the best safety and health of the communities would be. And so this new modification to that original previous modification no longer pays attention to that. And so I think that it's going to definitely send universities scrambling again. So I don't think there is a plan, if you will, to address a further resurgence of the COVID-19 with respect to students.
Yeah, and not to jump the gun, but in reviewing the complaint drafted by MIT and Harvard, there's one line in there that really speaks to this, Tejas, and that says, by all appearances, ICE's decision reflects an effort by a federal government to force universities to reopen in-person classes. And it goes on to say in the same clause, the effect and perhaps even the goal of this policy change is to create as much chaos for universities and international students as possible. So normally, in my experience, prior to 3.5 years ago, things would have happened in a very different manner. And I guess we're going to talk about at some point of what the APA is, the Administration Procedures Act, and how that applies to formal rulemaking. But in general, what's going on here, like as Kalpana said, is the government itself, and the way it's issuing these decisions and policies, is creating a state of chaos and uncertainty that has never really been in place in the modern immigration system. I'm talking about 1996 onwards, where a lot of these regulations and the immigration system we're in today, it came out of fruition from regulations that were promulgated in 1996 by Congress. So I think Kalpana hit the nail on the head, is we don't know. We don't know what's going to happen if, for example, New York State has a influx of COVID-19 cases, which I hope never happens, knock on wood, but it's possible, right? What if there's a second wave? And what if the school is forced to choose between staying open to meet the needs of the federal government policies, which is having in-person classes, but the New York State, Governor Andrew Cuomo, mandates that schools close? There's a clear conflict there between a state and the federal government, and will the judiciary even be able to resolve that in enough time to make an effective change or an effective policy for the students? So I think that's a theme that's been carried out throughout this administration in a number of different fields, but especially in immigration, that these policies are unprecedented. This crisis is unprecedented, and the role of each of the separate branches of government also comes into play here, because let's be honest, the executive branch isn't meant to legislate to this degree. It's meant that there are rules in place. There are procedures for these rules to change, and is the government following them? We'll see soon. And I don't want to steal your limelight, Tejas, but you can talk all about the litigation.
No, it's all good. It's all good. Well, we're getting a lot of questions that I think are really designed at ultimately some of the issues that are raised in the Harvard and MIT litigation. So, I think we should emphasize that obviously none of us that are a part of this webinar are involved with this particular lawsuit. It's going to be no surprise that we're glad that this lawsuit has been filed, and we're glad that another lawsuit is going to be filed possibly as soon as tomorrow by the state of California, which announced today that it was going to be suing as well. And I don't think it's going to be a surprise if other colleges and universities also decide to either join existing lawsuits or decide to file their own lawsuits. And if this happens, what we could end up seeing is a series of different lawsuits that are filed all over the country in different states by different institutions. And that's actually what happened with DACA as well. There's precedent for this. And ultimately, all those different lawsuits ended up being consolidated and going up to the Supreme Court, resulting in the decision that we had a couple of weeks ago. But the background here on the Harvard and MIT litigation is that this lawsuit was literally filed 2 days after ICE announced the change. So ICE announced this change on Monday, and on Wednesday, this lawsuit had been filed. And the parties, Harvard and MIT, are seeking a temporary restraining order and injunctive relief, which basically means that they want the courts to issue immediate relief that would prevent the government from moving forward with this policy. And really the premise for that is the imminence of the harm that they would experience. Now, the points that are predominantly underscore the basis for the complaint that Harvard and MIT have filed is the fact that this particular rescission of policy would prevent many students from obtaining a visa and would prevent them from being able to enter the United States. So as a result of the pandemic, you really had a group of individuals who stayed in the US, then you had a group of individuals who decided to leave. So if you were outside the US, and if your university decides that it's going to go all online, then this policy would prevent you from being able to return to the United States. Even though students may want to transfer to another school, how realistic is that at this point in time? So that's another point that they've made here. And they also emphasize that students who are in the United States risk being placed in removal proceedings as a result of this change in policy. They either have to choose between that choice or risking their lives by getting on a plane and flying back to their home countries. And ultimately, universities are then left with the choice between, as Harvard and MIT put it in their brief, having made these carefully calibrated decisions to not reopen in the upcoming semester, they're being told that you can either continue going down that route and therefore lose all these highly talented students who are a part of your institution. At Harvard and MIT, respectively, if you look at the numbers, it's anywhere from 20 to 25% international students. And those numbers are going to be consistent with what you see at a lot of different universities across the United States. Or they can choose to come up with some sort of hybrid program on the fly in response to this government directive, but thereby put everyone's health and safety at risk. So, we're not necessarily going to go through all the clauses of the complaint. I think what we really want to use this section of the presentation to establish is that a lot of the concerns that many of you have about the legality of the actions that ICE has taken and how this is going to impact you, that's exactly what's being reflected in the complaint that's been filed by Harvard and MIT. And we would anticipate that we will see similar points being made in the lawsuit that the University of California system is going to file, and any other lawsuits that any other university systems might file. In essence, yeah.
If I may, what would the impact of an injunction in the United States District Court of Massachusetts have on a student in Hawaii, California, Texas? Are they affected by a potential decision?
Great question, and ultimately it boils down to whether the court issues a nationwide injunction. Oftentimes with immigration matters, we have seen courts issuing nationwide injunctions because it doesn't make a whole lot of sense to issue a localized injunction when it comes to immigration policy, because immigration policy is national in scope. And so for those of our attendees who are wondering, well, what does this mean to me? Do I need to push the University of Hawaii to file its own lawsuit? Absolutely. Please push the University of Hawaii to file a lawsuit, because the more lawsuits that are filed to block this, the better. But there's value in the Harvard and MIT lawsuit as well, because more than likely, if a federal district court issues an injunction, it's likely that it would be national in scope as being limited, as opposed to being limited only to those two universities.
It should be noted that in the complaint itself, they're seeking an injunction of the rule. So it's likely to be national in scope just based upon what the relief that's being requested. But like Teja said, one of the things that we're going to be talking about is what you can do for yourself, and advocating with your universities to also pursue legal action is something I personally will encourage you to do, because the more the merrier, if you will, and the more likely, because this is a race now to see which district court judge is going to make a ruling.
And Colpin, on the same line, I know, does this bring back any memories from the travel ban and the litigation tactics used to combat that?
Absolutely. It's similar to the travel ban, to DACA, as Tejas referenced, and it's significant. Like in the state of California, it's significant that the Attorney General, on behalf of the entire state, is intending to file suit and seek injunctive relief. And that's not so dissimilar to what happened with Washington State with the travel ban.
Yeah, and we've received a couple of questions. We've received several questions. I'm just going to pick out a couple that I think are more relevant to this section, because some of the questions that have been asked, we're going to address in the Q&A section a little bit later on. But one question that was asked is, what if the court case takes too long and students have to leave anyway? Mm-hmm. It's a valid concern, because no one knows exactly how long this is going to take. But understand that in their request for a temporary restraining order, it's designed to achieve a very speedy and expeditious decision. So the idea would be that this is not something that's going to take weeks to drag out before the court decides whether or not to grant the TRO. It's known as a TRO, and arguments on this lawsuit have already started. In fact, arguments were conducted today, and it's likely that they will continue tomorrow. And we could see some sort of decision from the court as soon as next week, and typically when you have a TRO that's been issued, it's a good indication that a more permanent injunction is going to be issued. And that in turn is a good indication that, in the view of that particular court, the party that's moving for this injunction, in this case, Harvard and MIT, seeking to block this rule from going into effect, it's a good indication that the court believes that they're going to be successful on the merits of that argument. Now, of course, what's likely to happen going forward from there is that it's going to be appealed by the government. The government will then take it to a court of appeals and have to seek to have the court overturn that decision. And so that sort of starts the wheel of litigation. But all of these steps take time. If you look at the DACA lawsuit, you had that nationwide injunction that was issued. It finally resulted in a decision from the Supreme Court, but that whole process took well over a year before we got to the point where we had a Supreme Court decision. So, we obviously cannot make any predictions about where this is going to go, but I think it's important for you to understand that this is designed to result in a speedy decision one way or the other, even though it may be continuing to be litigated as we continue. Just kind of hitting the highlights of this complaint before we switch to the next section. Anand had referenced the fact that when ICE released its March 13th guidance, it said that it was a temporary provision, but it was going to remain in effect for the duration of the emergency. We don't know what's changed with regard to that emergency, because the coronavirus has only gotten worse in many states throughout the United States. And so the complaint itself points out that there's been no justification provided for switching out that earlier guidance. It's not as though the health situation is significantly improved such that we can now say that returning to in-person classes is safe and acceptable. So that's an important component of the argument that these universities are making.
And if I may, along the same lines, the minute I read the press release by ICE, someone posted on LinkedIn, and I took a quick reading of it, took a glance at it, and my first reaction was, this administration needs to make up their mind. Is the emergency over, or is the emergency not over? And the reason I say that is because the presidential proclamation, which was issued, I believe last week, references a lot of importance on the ongoing crisis with COVID-19. And that's a justification for a different part of the INA that deals with the presidential power over entry of foreign nationals. But if the justification for the presidential proclamation is in partly due to the crisis of COVID-19, and that's going on until December 31st, 2020, I don't think these two policies line up in certain ways. It's funny to me, and I know some litigators have mentioned this in other immigration tactics. There's a guy named John Wasden who argues a lot of cases. He used to defend the government as the DOJ, and now he sues the government all the time over these immigration denials and different cases. And he made the same kind of comment. It's like, either you can't have your cake and eat it too. Either the crisis is going on and it's a real problem in the United States, which I believe is supported by a lot of factual data, or it's not, and then you have the same policy throughout each aspect of immigration law. So I think it's something we could that might come up later on. I didn't notice it in the Harvard and MIT complaint, but this is something to keep in mind, that what justification is the government using in which circumstance?
Yeah, and I think that's a key issue here, that ultimately will dictate what the outcome is going to be. One of the questions that's been asked by an attendee is, what happens if the district court doesn't issue the injunction? Well, I would say that that's not going to be the end of the litigation. It's likely that the litigation will continue, potentially in a higher court. And the other point you have to keep in mind here is that because these different university systems are contemplating filing different lawsuits, you have one lawsuit that's been filed by Harvard and MIT, and then you're going to have the separate lawsuit that's going to be filed by the state of California. Those are strategic decisions that are being made by these parties as well, because all they need then is one court to issue a nationwide injunction, even if they don't succeed in the other court. And so there's going to be multiple opportunities to essentially make the same argument before different judges. So let's keep moving forward, because I know we have a lot of questions here that are coming in. We just referenced the fact that the University of California system is going to sue. I would encourage you to take a look at the press release. I know you all feel somewhat powerless right now. Take a look at the press release, because you'll know that there are people who are standing with you and want to fight back against this really inappropriate change in policy. Before we sort of transition into the next section, important to keep in mind as well that there are many, many fields that are dominated by international students, particularly certain graduate fields. Many thanks to Anand for helping us find this data, fields such as electrical engineering and civil engineering and so on and so forth. I'm going to, kick it over to Kalpana to take us through steps that you can take to help yourself right now.
Sure. Okay, that's the call to action, I guess. So first off, what we were talking about is, having the universities file suit. That's one thing. Pressuring them to come up with the temporary measures right now, including some form of the hybrid classroom. So obviously major universities are going to do what they do, but you as international students can also apply pressure to the administrations to come up with solutions, creative solutions that include some form of a hybrid classroom. Obviously, signing petitions and contacting your local representative, it's important to do that just to keep shining a light on the issue and not letting this just get swept under the rug. There's already a letter writing campaign that's happening in Congress, the House of Representatives, where my local congressman, he's signing on to, as are many others. And I think that, employers also could be advocates on your behalf. So it's not just universities, those places where you're having your CPT or your OPT. Those are institutions that rely on potential foreign student talent eventually, and this could significantly reduce the inflow of graduate students and other foreign students coming to the U.S. And there's the Indian government. This is geared towards the Indian student population. There are over 200,000 of you in the United States, and I think that you can consider having your government open up a country dialogue on your behalf about about these changes, because it's significant, because sending large numbers of students back to their home countries because no solution can be reached has a health impact, has an economic impact, disrupts everybody's education, and there should be a more holistic approach. And I think that the country-to-country dialogue is something that can be real and something that you should consider. And I do want to say there is precedent for this. I've participated in that precedent a decade ago with helping the Indian government negotiate certain rights for students at that time that were being treated unfairly by ICE. And so I just want you to know that this is something you can take into your own hands. Don't have to wait for a lawsuit. You can go directly to your own government to try to pressure our government.
So I just had a question for you, Kalpana, based upon that. So you said, you know, these are the things you can do and you don't have to file a lawsuit. Can a student file a lawsuit? Is that something you advise them to do? Do they have something what's known as standing? Could you talk about that a little bit?
I'm not sure they have standing on it. I don't want to pretend to know all of the possible constitutional angles that give them standing, but I think that when we talked about this previously, that we were not, we did not believe there was standing to sue because it's a change to the SABA system, which is something that the universities have to administer. So from that perspective, I had thought that they didn't have standing, and it could get quickly dismissed. And I think, frankly, the universities have incorporated the damages that students are facing into their current complaint.
Yeah, and I think the point that you're making with this slide is well taken, Kalpana, because you're basically pointing out that there are multiple different avenues to try to facilitate the change that we all want to see. We think this is a poorly thought out policy, and the way to get the government to acknowledge that and really back down is through the courts, but also through you know, the court of public opinion, as well as making sure that you're having pressure placed on them through friendly governments and partners such as the government of India.
And it just, you know, I mean, as immigration attorneys, we have seen this administration come up with numerous ill-conceived schemes where they hadn't really thought through anything, and literally it goes up on a Monday and it comes down on a Friday after they've received pressure. So this is possible. So I want you to believe that it's possible. You need to fight for yourself.
Completely agree.
So just to sum up, there's two buckets of things you can do. One is, what are the legal actions that the universities can take? That's the litigation efforts, and maybe if there's a TRO, if there's a permanent injunction, and then eventually the case will find its way to the appropriate court to make a final decision. But the other bucket of everything else you can do, please do it. Please sign these petitions. Please contact your congressman. Please. And like Teja said, the court of public opinion is based upon public shaming. And this is a shameful act by an administration that has shown xenophobic tendencies. I'm not hesitant to say that because I'm in New York and I see it every day. And at the end of the day, you have to do everything in your power to voice your opinion as a group also. So the more pressure you put together as a group of F1 students studying here in the United States, a group at this university, you can even pressure your local organizations. Kalpana was talking about this prior to this presentation. There's a lot of South Asian associations throughout the United States as well that have significant clout. I myself have partaken with events at the Gujarati Samaj, for example. And I'm not advocating that these be the chief proponents of making these changes, but you need to expand your networks, utilize your connections, and put as much pressure on this administration to revisit these policies.
Right, and absolutely, that's why the organization that's leading this today, NAAIS, I think they can be part of that voice for the students.
Thanks, guys. So we are getting a lot of really great questions. Before we try to answer any individual questions, but again, in a very general manner, because we cannot provide legal advice here specific to your situation, let's address some of the more common questions that are being asked and that were posed in advance of the webinar. And I think you're going to be handling the Q&A for us. Why don't you tackle the first one? In essence, the question is, the student is attending a school that's only offering online classes, and for whatever reason, the student is unable to transfer schools, what's going to happen?
Sure. So leaving aside the possibilities with the litigation that's happening, this slide is intended to kind of give you at least an idea of what you might expect. We're certainly all hopeful that we don't get to this point, but we want to make sure you also are aware of what could happen. So essentially, if you are only able to take the online courses, because that's all your university offers you at this point in time, then under the new modification that was made this past Monday, you will be deemed out of status. And unfortunately, that triggers certain actions that your school has to take by law. And one of those is to terminate your SEVIS record. So your SEVIS record will be terminated. And then once that happens, you're no longer able to remain in the US maintaining F1 status. You will lose your on-campus work authorization. I think there were some questions that were coming in through the chat that I wasn't able, the Q&A that I wasn't able to respond to. And you would have to exit the US, and to come back, you would have to have a new, you have to pay the new SEVIS fee and get a new I-20 to return to the United States. Now, one important thing though is your F1 visa is not invalidated. Okay, so if you had a valid, that still remains intact. So your return doesn't require for you to go to the consulate again and go through the entire visa stamping process. But it is what could happen, for example, is you might leave for the fall semester and then try to come back in January if things change at your university. I also need to mention, because people talk about grace periods and those get thrown around a lot, and there are different types of grace periods that work in the F1 context, but when your SEVIS record gets terminated, there is no grace period for your stay in the US.
Thanks for that, Kalpana. So let's move on to the next common question. I know that some people are thinking about taking a semester off in response to this pandemic. Is that an option for international students?
Yeah, absolutely. You can take a semester off. You can negotiate that with your university, but there's not an option to stay in the United States. You do have to depart the United States once the moment you ask for that semester off, unfortunately. And then you need to be very cautious about how much period of time that you're out. If you are out for less than 5 months, then you can reconnect with your university saying, I'm ready to come back. They can reinstate, well, it's not reinstatement, but they can reactivate your SEVIS record so that you can return back with your reactivated SEVIS record, your I-20, and the visa that you have in your passport. If you're out for more than 5 months, though, then your SEVIS record will be terminated. That number can no longer be used. You'll need to get a new SEVIS record. You have to pay a new SEVIS fee to return. But these are things, if you do this, you need to coordinate this with your school. You need to take certain permissions per your school policy that are in concert with immigration laws. So don't just leave next week without talking with your school. You want to keep your options open and make sure that there's a coordinated process with your school.
And if I could just add, and I'm certainly not trying to make excuses for institutions, but recognize that many of these universities and colleges have been caught as off guard by the situation as you have been. And some of these institutions, may have several thousand international students, and they may have been inundated with questions from students in the last 3 or 4 days. It's certainly understandable in a situation like that they may still be trying to figure out what their strategy is. They don't necessarily have any greater insight on options than what the modifications announced on Monday said. And that's precisely why we're seeing lawsuits. So you may not get all the answers that you're looking for immediately. And that's okay if you don't get all the answers immediately. There is going to be a period of uncertainty that you might need to deal with. Really just, continuing to advocate for yourself and informing yourself as you best can by attending programs like this is a good idea. This is going to be a very fluid situation. We may see in a week that circumstances have changed and the advice looks different as a result of further developments. So let's keep moving forward. Next question, can an international student take a reduced course load?
Yes, you can. You can take it up to about half the number of hours, but there's very specific bases for doing so. These are all by regulation. So there's one that relates to academic difficulties. I think the second one is, let me see, medical conditions. And then if you're in your final semester, you can take a reduced course load. That's the existing law, so that law hasn't changed. I don't know if you, certainly with COVID-19, if you have a diagnosis, then that's something you can pursue, get a doctor's note that would provide the documentation that your school requires to take the reduced course load. The reduced course load must be approved by your DSO, designated school official.
And one other consideration there is that if you're somebody that perhaps has certain pre-existing medical conditions, and you're fearful about the possibility of being in an environment where you might get COVID-19, that might be a basis for a medical condition. I would imagine that universities and colleges are going to be more liberal generally in allowing for those sorts of medical conditions. Certainly they don't want to have the liability of you.
Yeah, I mean, it's important to note that it's not USCIS, not US Citizenship and Immigration Services or ICE that is adjudicating whether you get the reduced course load. It's your university advisor. That's who you're going to be working with for this.
So the next question, can an international student defer enrollment?
Yes, and I think this is something I probably would advise, right? Because especially for incoming students, new students to the United States who are having difficulty getting visa stamped, many university web pages on their international sites are telling students to consider deferred enrollment in order to be able to ensure that you're not taking on a tuition payment and then being subject to this new modification because you can't maintain your course load. So definitely it's something that you should do. It makes good sense.
And the closure of consulates that's being referenced here has nothing to do with the modification that was announced on Monday. That's a product of the fact that US consulates across the world have by and large been closed since March of this year as a result of COVID-19. Unfortunately, we do not have a clear indication of when the consulates are going to reopen. Personally, I suspect that we're going to see sort of a rolling opening of the consulates where they reopen in certain countries that have perhaps lower COVID-19 numbers, and later on in countries where COVID-19 numbers are a little bit worse. So it's very difficult to predict when when consulates are going to reopen. And so that unfortunately then could mean for people who don't have valid visas as of right now, that it's really uncertain when you're actually going to be able to obtain your visa. What about concurrent enrollment in two different institutions?
Yeah, I was looking at those rules because I was wondering, can you just string together, like some online courses one place and in-person courses elsewhere? I don't actually know the answer to that. I know concurrent enrollment is possible. I know that you can put together a full course of study by going to two different institutions, but I don't know whether how it works in terms of, if you end up taking more than one, if you take one online course, maybe one place, this should work, and then take possibly one online course at the other might work. I'm not sure of the answer to that. I just threw it up there for people to explore this at least with their DSOs.
And I think the point that you may also be making here, Kalpana, is that given how uncertain it is, students have to be very careful in assuming that this is going to be a solution to the problem.
Yeah, absolutely. And I do want to say, unfortunately, the way immigration law works is if your DSO makes a mistake in how they're interpreting the rules, the DSO doesn't suffer, the foreign student does. So again, I don't know the answer. I thought it was worth at least highlighting that this may be something that requires further further possible investigation.
Great. What about transferring to another school? What circumstances allow somebody to transfer to another school, and what are the procedures involved there?
Well, I mean, people can transfer at any time that they want to, but they have to get the SEVIS record to be transferred. And I think that that's the issue that I'm seeing, is how quickly that can be done. And I think that's being pointed out in the litigation, that it probably can't be done within a false start. Tejas, you may know these rules a little bit better than I do. I believe there's a way that it works, that as long as your school is going to be starting within 5 months of your request to transfer, that that you can remain in the U.S. But I wasn't entirely sure, so I wanted to maybe kick that one back to you if you know the answer to that.
That's generally my understanding, but I'm not certain of that either. I think the question here that perhaps is not clear also from a timing standpoint is, you know, what needs to happen and by which date in order for a student to be able to transfer into another institution in the fall semester. My understanding of these guidelines, if they remain in effect, is that they would apply to fall semester enrollment, which means that, you know, if a university has a start date in August, there's only a few weeks left before the university restarts. So does the, you know, your outgoing university needs to, in essence, allow you to transfer. The incoming university needs to allow you to transfer in. You need to have I-20s issued by those institutions. That's a lot of steps that need to be completed.
That's a lot of steps, and it's
and
unlikely in many.
Right here. The regs also state that the new I-20, the AB form, it has to be returned to the DSO 15 days prior to the start of attendance.
Yeah.
And if you're thinking of finding a school to transfer to, applying to that school to transfer to, on top of the immigration paperwork required, you're asking a lot for anyone, given just the general timelines of when universities open.
Yeah. And then I think that we're not trying to pour cold water over any ideas that you might be trying to pursue right now. We understand that everyone's scrambling to address these issues, but we also want to give you a realistic sense of the challenges that are going to be involved with attempting to transfer out from your existing institution. Precisely why these lawsuits have been filed, quite honestly. You know, it's not a very realistic idea for a whole bunch of students to take in short notice. What about reinstatement?
So I wanted to put that out there because some people have, I think I even saw some messages related to that, and that's if you do indeed not able to attend a school where you're able to maintain your status, can you pursue reinstatement of your status in January, or like in the next semester? And these are the current rules of reinstatement that are up on the screen. I think the most important one is whether you can show that the violation result of circumstances beyond your control. And that's political, right? Because obviously it seems beyond your control. You didn't create a global pandemic, or you couldn't control the fact that your university did not offer you in-person classes. So I think this is argument. It's, you know, fodder for argument. I'm not sure how it'll be ultimately treated, but if you get to that point where you have no other option and you are planning to remain in the United States, then you will need to find a university that's willing to issue you something called a reinstatement I-20, so that you can try to apply at the next available term that'll allow you to then get back into status.
Thank you for that, Kalpana. What is the hybrid course model? What does that really refer to?
Well, yeah, I'm trying to understand that, right? Because I think what it means is that, you know, it's a combination of some in-person class and online courses, but it seems like what they're saying is that the school has to then present the program to the SEVIP system to get it approved for it to be considered as part of the hybrid under this modification. So traditionally, the hybrid program has meant at least, you know, some sort of physical in-class along with online. So I guess, and I think what that ends up saying, there's the argument, because it's written rather strangely in the modification. They're like, you can take more than one online course. Okay, but did they mean more than one hybrid course? Because you'll be taking a whole bunch of it online, and then you'll meet like one Saturday a month in person for 8 hours. I'm not sure. I'd love to hear what you guys are thinking, but the way I'm understanding it, that's possibly what that means, is that you basically could take maybe up to 3 hybrid courses, largely online, but with a little bit of in-person component. And perhaps that might even cover people who are doing independent studies or research with their professors, working in labs. So again, it sounds like something that the university has to present and put forward as their plan for the hybrid model. There is not a lot of clear guidance, and we then have to revert back to how those terms have been used in the past, which would be online plus in person. And then the online usually requires some aspect of confirming attendance as well. So I
And
don't know what you
since
guys are thinking.
brought that up, the Twitterverse is all over this one tweet that NYU and Columbia have created this unique in-person class. I couldn't find any official documentation to support that, but I'm assuming it's related to this potential model that might circumvent the purpose of this, rescinding these regulations to some extent, and enable students to remain enrolled in the universities they're in right now. So I guess we'll just have to wait and see.
What is that? What is that model on it? What is it that they're
my understanding is that they're going to offer, well, it's proposed, my understanding, that they're going to offer one in-person class, and that one in-person class will be geared towards enrolling students that are on visas, and in doing so, they might be able to comply with the terms of the regulations, in terms of they're now enrolling in a class, in a course of study that's both in person and online.
Right.
So I think ingenuity is the only way to go these days, and the more creative you get with some of these regulations and policies that the administration is taking, sometimes that works. So we'll see.
Yeah, and I think that addresses one of the questions that was asked by an attendee as well, which people are a little bit confused about whether the new ICE policy allows only one online course if you're doing the hybrid model, or essentially the opposite. And really what the hybrid model, what they said in this new updated policy as of Monday is, if you're going to do the hybrid model, there must be at least one in-person class that's a part of that model. So in essence, what they seem to be saying is that the floor there is one in-person class. Everything else could be online, but the university needs to certify that they are doing the minimum number of online courses that, they feel comfortable with, or that they think is appropriate given the circumstances. Now, of course, if universities are concerned enough about the pandemic, it's more than likely that they will minimize the number of in-person classes. But theoretically, at least, this model could meet the guidelines.
And the tweet I'm talking about is not true. We have someone in the Zoom chat telling us that it's not true for NYU. So, like I said, it's just big in the Twitterverse, but there was no factual basis for that as far as I know either. But, yeah.
Got it. I know we're coming up on time, but we've gotten some questions about OPT, and I think we should spend a little bit of time talking about OPT, because particularly for students who may be in their final semester or their second to final semester, who may be having difficulty getting back to the US, either because they don't have a valid visa right now, or they're not sure whether they're going to be able to stay in the US given this new directive. What should they be thinking about with regard to the validity of their OPT? Kalpana, do you want to take a first shot at that?
Well, so there's pre-completion OPT and post-completion OPT, right? There's different types of practical training, and then there's curricular practical training. So the one full academic year comes from the regulations, and I think people have been worried about that in terms of how that affects them. I think the way I understand the rule to work is that if you've had, one full academic year, you can still apply for, even if you have a break, I believe, in between, because you may have met it in the past. So I think that would be the main concern people are having, is if they have to take if they're deferring by a semester or taking a break for a semester, as long as they had that one full academic year prior to their applying. But in general, if you're on OPT, and I saw several questions like that, and I was trying to answer them rapidly on the Q&A, but if you're on OPT, you are not directly impacted by this, because this is all about people who are taking a full course of study. I think there's other questions related to CPT and the impact on CPT with this. And again, those are sort of separate issues that are happening. You still can be eligible for your CPT, but you still need to be maintaining your full course of study the way that it's been described in the new modification.
Thanks for that, Kalpana. Yeah, go ahead.
Just on the screen is just some other timelines that people need to remember, and these are just the existing regulations, just to remind everybody what are all the other considerations they have to have.
Yeah, and there were questions asked about whether we're willing to share the slides, and absolutely, I think that's the plan. Sejal, feel free to correct me if I'm wrong, but my understanding is that we are going to be sharing the slides with attendees who are here and those who couldn't make it.
No, absolutely, and additionally, they will be available through our Facebook Live streaming as well. So
Great.
People can kind of see through that with the conversation, and we can distribute this afterwards as well.
Great. I know we're running a little bit over time. Happy to, maybe just work through a couple of other common questions to the extent that the others have time to do that. One question that I've seen come up a couple of times is whether we can talk a little bit more about what happens if a university that starts off being hybrid decides to go online mid-semester, online entirely because of a change of circumstances. And as I understand it, and I know we talked about this a little bit at the beginning of this webinar, but as I understand it, under this new exemption, what SEVIS is saying, what ICE is saying is, sorry, but if we go completely online, we're no longer to leave because you're not maintaining status anymore. And that's precisely one of the issues that is being raised in these lawsuits, because clearly it's going to put a lot of students in a very difficult and compromising situation. They have leases, they have bills to pay as students over here. And so, again, I would caution that we have the worst case scenario under this particular policy, which we are optimistic and hopeful that it will not go in effect. And then we have what is likely to be, well, what we hope will be the outcome, which is that these rules will be set aside, and we can have a more humane approach versus what's been proposed here.
Yeah, and arguably, Tejas, this is a place where reinstatement might make sense at that point in time, because it's mid-semester and it's and people are suddenly losing access to their universities, and that's arguably a circumstance beyond their control, especially if they had tried to comply prior to it. Again, these are all arguments that you would make if you got placed in that circumstance.
Absolutely.
We should talk about enforcement if we have a minute. I don't know if we do, or the call gets cut off. Or so, because many people I think are very concerned about this. Is ICE going to be coming and knocking down my door? I think is something people may be weighing on their minds. Typically for F1 students, the primary vehicle for enforcement is SEVIS termination. Okay, so it's not usually ICE out on the street rounding students up. It's typically the SEVIS termination. If ICE does come to your home, though, you do have certain rights. And I think SABA, South Asian Bar Association, I believe, has information about what your rights are with ICE potentially on our website. I know that the ACLU has it, and I've done know your rights programs with the ACLU on this topic. The things to do are, so number one, you do not need to let anybody into your house or your apartment if they do not have a warrant and an ICE warrant is not actually a warrant, or you know, you have to have some sort of an order that allows them to come in. If you are in a household with students who are not F1 and other students, you know, you might want to have them answer the door. Do not run, though. If you do encounter ICE, we do encourage you to be, you know, to take personal precautions, not to run away or try to and instead, you know, you can contact an attorney who can assist you. But there are lots of Know Your Rights materials out there. I just suggest you have them, not to scare you. These Know Your Rights are actually to help you understand what your rights are so you can protect yourself. But I do want to make sure you're not thinking that there's large, you know, plans to go sweep the streets for F1 students. At most, usually it's the SABA's termination is the primary enforcement vehicle.
Right.
And just to add to that, be careful where you get your information from. In general, for what I've noticed, I've done a lot of high volume H-1B cases throughout the years, and a lot of my clients seem to think they know everything better than I do, and they might in some circumstances. But be careful going to online blogs, listening to other people, their opinions, and what they think is going to happen. Sometimes, especially if things are so fluid, try to make sure you're getting credible information from credible sources before you make a important decision in terms of maybe switching schools or trying to make travel plans and things of that nature. So always make sure you get proper guidance and you're informed, but be careful where you get your information from. That's the last caveat I have.
All right, well, I know we're past an hour and we got a lot of questions. We tried to answer as many of them as we could. There were some that we simply didn't get to, and we apologize that we weren't able to get to every single question that was posed here. We are going to try to continue our engagement on this issue. You know, SABA is very committed to continuing to be a resource for folks in the community who, frankly, are feeling the whiplash and impact of this chaos. So as the situation develops, please feel free to continue checking in. Sejal and Sudhanshu are resources for you, and we intend to keep an open chain of communication with them to see how we can continue helping. But I don't know if there's anything else, Anand, Kalpana, or Sejal, that you would like to add before we close.
No, just to echo that, I think, you know, one thing I'll definitely make sure we do is the outcome of the TRO hearing. We'll definitely disseminate that information to this audience, and any significant developments that we can share, we'll try to keep everyone informed as well. So.
Thank you so much, Kalpana, Anand, and Tejas. All three of you have been so insightful and so helpful to clear up the confusion a little bit. And we're so happy that we had the chance to host you on this platform on behalf of NAAIS, but also for NAAIS, I apologize. We will be, you know, keeping up to date on our social media as well. So please do follow us. Thank you so much for everybody who did join us here today. And I hope that we were able to help support everyone who did reach out and to answer some questions and provide some clarity.
Thanks for having us.
Thank you for having us.
Thank you very much.